Now, the Attorney General, Godfred Dame Yeboah, and the lawyer for broadcast journalist Regis Kai-Pakwesi Abedu spoke to the media after the proceedings.
By law, when an application is before court and it has not been determined, although it has not expressly been stated granted or not granted, but once it is pending, we don't do anything to prejudice the outcome of the application. So we say that invariably, indirectly, it is still restraining any party from doing anything contrary to the demands of the application.
I mean, for clarity, as far as you are concerned, you do not expect Parliament to transmit the bill at this stage?
No, can't do it so far as this matter is pending. Otherwise, it will amount to contempt of court. To the best of our understanding of the law.
When the court says early trial, what's your understanding of that? How different is it? Early trial.
When the court speaks about an early trial, in effect, what it means is that it will speed up the process towards the determination of the matter, so that this whole issue of injunction before final determination will no longer take a center stage.
I think that's the main issue. I mean, the point is that the country ought to know that we're a country governed by a constitution. The constitution that prevails over everyone. We're all under the constitution and the laws of Ghana. And therefore, the actions of every person must be determined within the premises of the law. Same as a person can even question my constitutional right to prosecute in this country. I've seen that many times. Citizens of the country even file applications, the Supreme Court questioning the Attorney General's power to enter and prosecute in a certain matter and that kind of thing. And it comes up for determination of the Supreme Court. It's the same way that a decision or an action taken by Parliament can be questioned by citizens of the country. And so, for me, the questions are raised during the hearing of the application for secretary injunction, where ones that for me have not been determined in this country, and today it has not been determined. It's the very first time that a private member's bill is, or issues regarding private member's bill are coming up for determination. For private member's bill are quite novel. It occurred only in the time of the former parliament, the 7th parliament, headed by Speaker Professor Michael Quay. It was in his time. Of course, it was with my help as Deputy Attorney General that we all sat down, we had a roundtable conference, and then we sat down to craft ways of empowering Parliament to engender or produce its own bills. And it was in the time of the last Parliament headed by Professor Quay that the first Parliament members bill was passed. And really was without controversy because it did not have any implications for the taxpayer. Now, there are a lot of bills being churned through Parliament now on account of private members, which really have implications for the public purse. And I think for me, as the Attorney General of the Republic, it's a question of important consideration that the court ought to really consider. Because since 1957, as I indicated to the court, since 1957, every constitution the country has had, apart from the 1961, has had provisions on Article 108, which is akin to Article 108 in it. And there has not been any case at all filed questioning the circumstances, the ambit, or the extent to which a person can commence a bill which has implications for the taxpayer, but which do not go through the requirements of Article 108. So I think the court ought to consider such a case. And as I indicated, is a case where every person in the country ought to know that this action ought to be in accordance with the Constitution. And we all live under the Constitution of the country. That's a country that we all seek to build. It must be in accord with fairness, and that's why we say it's a country surrounded by freedom and the rights of the people.